Hey guys, John Ween, attorney and senior legal instructor with Blue to Gold Law Enforcement Training, coming to you today with another roadside chat. Today's question regards standing and abandonment. And the question stems from a example that we use in some of our classes, primarily our advanced search and seizure class. And the example is this. It's late at night, maybe a high crime area. You are walking around, you're working your beat, and you come across a group of subjects standing around a backpack. And so you go up to make that consensual encounter just to let them know you're in the area and see if there's anything that they need, right? And so you walk up and you say, "Hey guys, how's it going tonight?" "Oh, sweet backpack. Whose is it? Is it yours? Is it yours? Is it yours?" "Ah, it's nobody's backpack." You dive in and you find guns, drugs, whatever, and this guy's ID, right? And so you arrest him for possession of the narcotics and probably possession of the weapons as well. Question is, why are you allowed to do that? Well, the Fourth Amendment does not protect abandoned property, right? There is no constitutionally protected interest in abandoned property. In order to have standing to contest the reasonableness or unreasonableness of a governmental search, you must have standing. You must have skin in the game. You must have a horse in the race. As the court has previously said repeatedly, you cannot vicariously assert Fourth Amendment rights. And so, in order to have standing to file that motion to suppress, to argue the reasonableness of a governmental search, it has to be your Fourth Amendment rights that are implicated by what the government did. And so, if you have no constitutionally protected interest in that effect that is searched, well, then you don't have a dog in the fight. You don't get to file that motion to suppress. And so, yeah, we are still going to charge you with possession of those items, but you have no standing to contest the reasonableness to make the argument that it is unreasonable that that search was conducted. However, what I will tell you guys is if you just approach it that way, right? If I walk up, "Hey, is it yours? Is it yours? Is it yours?" "Ah, it's nobody's." You leave yourself open for a defense attorney attack. Better approach is this. You walk up, you say, "Hey guys, how's it going?" "Oh, sweet backpack. Whose is it? Is it yours? Is it yours? Is it yours?" "Okay, guys, listen. Does anybody have anything to do with this bag? Anything at all?" "No, no, no, nothing." "Okay." And then you dive right in. You are the one who's going to have to convince the court that there was legitimate abandonment here. And so if you do it that way, say, "Do you have anything to do with this bag?" What you are asking them is if they have any constitutionally protected interest, any vested interest in this bag that the courts will recognize as legitimate as a basis for them to have standing and contest your search. No, nothing. Okay. If you don't do it this way, if all you do is walk up and say, "Hey, is it yours?" "No." Great. You leave the door open for a defense attorney to make an argument. "Well, it's not my client's," right? It's not. And the officer came up and he asked my client one question, and that was, "Is this your bag?" And my client honestly answered him no. The officer then just dove right in. Had the officer taken the time to even ask just one more question, of course my client would have immediately told him that it's not his bag, but it is his brother's, sister's, boyfriend's, girlfriend's, cousin, twice removed, whatever that he is holding for that person. And so he does retain a constitutionally protected interest in that. The better approach, "Hey guys, does anybody have anything to do with this bag?" "No." Well, there you go. Abandonment. Now, if you guys are looking for some cases on point, some cases on standing, I highly recommend you check out Rakas versus Illinois out of the United States Supreme Court. And basically, what Rakas said is that if you want to, contest the reasonableness of a search, you got to have standing. You can't vicariously assert those Fourth Amendment rights. Another case is United States versus Byrd. United States versus Byrd. That's BYRD. We'll throw a link in the comments below. That's out of the United States Supreme Court again. Another case is Mangum. We'll throw that link in there too. That talks about abandoning a duffel bag in the trunk of a car. Abandonment equals no standing, no legitimate expectation of privacy, no basis to contest the reasonableness of a governmental search. I hope this helps, guys. If you have any additional questions, please always do not be afraid to reach out to Blue to Gold Law Enforcement Training. We are here for you. Make sure you guys do sign up for our free webinars. If you attend, you get a certificate. If you're not able to attend live online, we'll send you a recorded version. Set yourself up for success. We will do what we can to help you make sure you get it right every time. Until next time, I'm John Ween with Blue to Gold Law Enforcement Training. Be safe. We'll see you soon.